Hello, my name is Rebecca Mastee with the Michigan Catholic Conference, the official public policy voice of the Catholic Church in this state. I would like to speak with you briefly about the Religious Liberty and Conscience Protection Act, Senate Bill 136, sponsored by Senator John Molinar. The purpose of this bill is to maintain religious liberty and conscience rights, which our nation has cherished for over 200 years. Unfortunately, these constitutional rights are slowly eroding as government mandates are forcing individuals and institutions to act contrary to their religious teachings. Senate Bill 136 seeks to protect conscience rights by providing legal protections to those in the healthcare field. Many of these protections already exist under federal law, but are lacking in state law. Specifically, the bill would allow healthcare professionals to assert a conscience right regarding elective, non-emergency procedures. It would allow employers to offer their employees a benefit plan consistent with its institutional beliefs, and it would ensure that under no circumstance will a patient or prospective patient's care be compromised. Unfortunately, opponents of the bill have sought to distort the intent and details of the legislation. They say the bill would allow for emergency care to be denied and that patients could be discriminated against. A review of the legislation will prove these claims are false. I would like to explain how. Senate Bill 136 protects patients by strengthening existing laws. Federal legislation strictly prohibits hospitals from denying emergency care to anyone. This bill strengthens those protections by prohibiting any person or institution from denying emergency medical care to any person. That's important to know. Senate Bill 136 also protects the status quo by mirroring civil rights laws. Several federal policies, such as the Church Amendment, the Hyde Amendment, the Weldon Amendment, and others, ensure the federal government does not discriminate against those who assert their conscience rights in health care. Numerous presidents and Congresses of both parties have consistently passed and signed appropriations legislation upholding these rights. It's time for Michigan to provide the same civil rights protections. Let's also discuss how Senate Bill 136 strikes a balance between employers and their patients' needs while upholding employee religious liberty rights. Quite simply, the legislation allows an employer to craft an employee accommodation policy in advance of any elective, non-emergency procedure or service that an employee may find objectionable. Sterilization or services that impact end-of-life care are important examples. To alleviate concerns about discrimination, the legislation specifically forbids an accommodation based on a patient, or any patient's ability to pay for a service. Senate Bill 136 is about protecting individuals and institutions from discrimination, as federal law already provides. Thankfully, Michigan has provided conscience protections for over 30 years related to abortion procedures. This policy has worked well, just as Senate Bill 136 will accomplish for other elective procedures. In fact, measures similar to Senate Bill 136 have been in place in other states for several years. In Illinois, legislation has protected conscience rights for over a decade without compromising patient care or employer needs. So let's join together as Michigan citizens with appreciation for our differences and say yes to Senate Bill 136. Let's say yes to conscience rights, and let's say yes to protecting civil and religious liberties. I'm Rebecca Mastee with the Michigan Catholic Conference. Thank you for your time.